All right, still with me, trial attorney Matthew Barhoma. Matthew, great stuff there, by the way. Is it is it anecdotal, or do you see some sort of trend forming here?
Yeah. I mean, especially in the last year, there's definitely been a trend where defendants have been taking the stand, and every time, there's a very similar discussion. Should they? And it's different in every case. Every case presents different facts and different defendants, different personality types, different kind of things that you may want to expose to the jury or possibly not expose to the jury. And so it's actually quite as important as every single time we discuss it, which is, should this defendant waive their Fifth Amendment right? Their Fifth Amendment right is a liberty that is actually very important, causes for mistrials in some cases. And so really something that we really do have to tippy toe around and determine every single time.
Yeah, and we talk about that Fifth Amendment right. The jury's told they can't hold it against the defendant, but I think sometimes they do. I had to search, Matthew, for some kind of studies on this. There was one small study done in 2008. The National Center for State Courts collected data. They talked to judges, prosecutors, and defense attorneys, and what they found was a couple of things. Number one, judges are more likely to convict than juries, so they looked at that. But they also found that juries were more likely to acquit when the defendant testified. And acquittal rates go up when the defense puts on a case rather than not putting on a case at all. Any of that surprise you?
No, actually, it really doesn't, because I believe that jurors are more likely to sympathize or empathize with defendants if they take the stand, if they tell their version of events. And not only that, there's just something to be said about honesty. And when you take the stand and you present that to the jury, that could resonate a lot more. And so in some cases, it could make a lot of sense. And these statistics are totally in line with what I would expect for defendants taking the stand and acquittal rates.
Yeah, no question about it. And I think one thing that we can say is fair, like the Kim Potters, Amber Geiger, Travis McMichael, Kyle Rittenhouse, many of the people we saw in that piece there, none of them had criminal records. That would be one of the caveats as a defense attorney. You don't want to open the door for stuff, prior convictions or prior issues that would be inadmissible by taking the stand, right?
Absolutely, and that's why there are a lot of defendants we don't talk about who never take the stand, because it comes at the advice of counsel a lot of times, not to do it, especially where they're going to be receptive to a lot of cross-examination on the merits and also about their credibility, about their person. That's always on the line. And so, there's always a lot to decipher there, a lot to go through when you're determining whether or not a defendant should take the stand.
Yeah, I think it's a little bit of a trend. I'll be honest with you, Matthew. I think more and more folks are, in this day and age with the video and everything else, more and more people want to see from and hear from that defendant. Anyway, we're going to take a break. Matthew, stand by. Coming up next, Brian Laundrie.